2166FH, 12418FC.
Good afternoon, Your Honor. Blake Hatlum on behalf of the people.
Good afternoon.
Good afternoon, Your Honor. James Fifelski on behalf of Harvey Wince, who stands to my right.
And good afternoon, Your Honor. Robin Stevens. I'm on the violation of probation case.
Thank you.
Your Honor, this is the date and time set for sentencing as well as the violation of probation matter. Mr. Wince is up for sentencing on 3 counts, which are the principal charges he's being sentenced for. There were 2 pre-sentence reports compiled, one for the resisting, I think simply because that was the first one out. It was pled to initially, but I think Mr. Hatlum and I both agree we don't need to worry about guidelines or scoring on that. We can just do the scoring for the count 1 charge.
Okay.
Agree with that, Mr. Hatlum?
I do.
You know, quite frankly, I only have the one pre-sentence report, and I noted that it didn't mention count 3. Was the other report done a while back, or?
Yes.
Okay.
It was
so-
done sometime back in, I think it was January 30th.
Okay, so it's probably buried. Oh, this might be it. February 1st, I have, yes, I do have that here.
Okay.
So you've had an opportunity to review the reports with your client?
Yes, I have. Mr. Wince, did you also review both of these pre-sentence reports?
Yes, ma'am, I did.
Okay. The only correction I would make on the resisting and assaulting and obstructing an officer report is the sentence date could be corrected to reflect today's date. And that, I think, is the only correction. And the jail credit should also reflect today's current date.
So that would take it up to 393?
That's what I've got, yes.
Is that correct, Mr. Hatlum?
That's correct, Your Honor.
In terms of the other pre-sentence report, again, just to change to the sentence date on the cover page to reflect today's date. I was appointed on that case, so that should be modified as well.
Okay.
I only have one request with regard to the sentence guidelines, if now is the appropriate time.
Is there anything on the scoring that you wanted to bring to my attention?
Yes. In terms of offense variable 7,
Okay.
that's scored at 50 for aggravated physical abuse. Your Honor, I know that the jury has spoken in this case, and other than filing an appeal, there's not much I can do to take issue with that other than to state that you've heard Mr. Wince's testimony throughout this case, and I think in terms of what happened, what may have happened, what the jury concluded, there could be different things in terms of those 3 categories. I would ask Your Honor to score that at 0 based on the testimony of my client, which was supported by character testimony, and I think that there was evidentiary support for the fact that this was an accidental burn. Now, the jury made its conclusions, but again, that's the basis of my request for OV7 to be scored at 0.
Your Honor, we would ask that it remain at 50 points. The use note says that the victim was treated with sadism, torture, or excessive brutality or conduct designed to substantially increase the fear and anxiety a victim suffered during the offense. Obviously, Your Honor has sat through this trial. Your Honor had an opportunity to view the pictures of this case as well as hear the expert testimony of what those injuries consisted of. And we had a multitude of injuries, probably more than we could list at this period of time, but just the most serious ones were obviously the bite mark, the lacerated liver that could have resulted in death, and obviously the 18% of his lower body being significantly burned. Those obviously account for excessive brutality. And to the extent that the jury should consider the defendant's testimony, I think that they did that. And if they were to have believed the defendant's testimony, he would not have been convicted, because his testimony was quite clear that he had an explanation and accounting for every injury, and they were not as a result of anything he had done. So I think that by virtue of the fact that he is sitting here about to be sentenced by Your Honor reflects the jury's determination that he was in fact responsible for all of these injuries, and I would ask the court to order 50 points.
Well, I do agree with Mr. Hatlam on this. The jury did find him guilty of torture, and the evidence did support it. So I am keeping OV7 at 50.
Your Honor, I have nothing else in terms of corrections, just allocution at the appropriate time.
Anything on the guidelines and the scoring?
No, Your Honor.
Victim impact statements.
No, Your Honor.
Okay. Then you may proceed, Mr.
Thank you, Judge.
Kwiatkowski.
Your Honor, I'll be brief. I think that there are a couple of things that are worth highlighting here. One is, while my client does have something of a criminal history, it's not as extensive as a lot of people we see in these courtrooms. And he was on HIDTA status at the time. He was given that benefit presumably because he was someone who probation and the court could believe in a certain sense. And I think that speaks to his prior character coming into this. And again, the jury has spoken in terms of the evidence in this case, but in terms of his previous convictions, I think the fact that there are no prior assaultive convictions, the fact that throughout the trial there was no evidence of a motive or rationale for doing this. The testimony of my client, which was that he was taking care of this child, and the reasons that he gave for explanation of some of the injuries, but what he did throughout the day. The fact that he was the one who was repeatedly asking the mother of this child to go to the hospital show that he was someone who was concerned about this boy. He didn't run from police. He repeatedly cooperated with police. Yes, he got upset when he was finally arrested, and we've dealt with that here in this court, but the fact that in many other ways, Your Honor, he was cooperative, he was someone who did not indicate the kind of things that would be consistent with somebody who would do this again or who would even do this in the first place. It's my understanding that this young man is healed up. There's some scarring, but I think in terms of physical injuries, I understand that he is, for the most part, a normal 3 or 4 year old boy. Your Honor, my client has a son of his own. He's involved in proceedings, as this court is aware, this very day about his son and parental rights. But what I would ask Your Honor to do is sentence him at the bottom of the guidelines. The bottom of the guidelines, keeping in mind that he is a young man, that youth can do, and the courts have recognized that youth do certain things without the benefit of the wisdom of age, and that the bottom of a guideline sentence in this case is going to be a very hefty sentence to begin with. And the chances of being paroled the first time or the second time that he sees the parole board are slim to begin with as well. So a bottom of the guideline sentence, I think, will serve all of the interests of sentencing for this particular case, and that is my request, Your Honor.
Well, Your Honor is obviously in the optimal position to judge this case, having heard the facts of the case, having heard the witnesses, and I would argue most importantly, seeing the injuries that Julian sustained in this case. Julian is a 3-year-old child. Therefore, he takes his victim as he comes, and in this case, you had a child who could not talk. So we have only ever heard one side of the story, a story that no one believes, and this jury did not believe, and I don't believe Your Honor believes that the defendant's version of the events has any rationality or basis in truth. So what people have asked me and what defense counsel raised is that same issue. I actually had someone ask me that just the other day. Why do I think the defendant did this? And my response is, I don't know and I don't care, but now let's make sure he doesn't do it again. And I think that the fact that there is no rational reason for this level of brutality and assault on a child should give this court serious pause when deciding how to treat this defendant. The lack of an explanation and the lack of any rational motive for this level of assault, I think, requires this court to sentence him at the top of the guidelines in this case. The defense counsel, and I understand what he means by saying that he has a normal life in the extent that Julian is alive, But he has permanent scarring, and the evidence is conclusive that when third-degree burns have removed the obvious above layer skin, it's not going to come back, and they can't graft it because of the flexible nature of the foot. So this young boy, as I look forward at his life, and I hope it's prosperous, and I hope that he is active, in 15 years he's going to be in a locker room, and he's not going to have any skin on his legs, and he's going to have to explain that. In 30 years, he's going to want to have a family, and he's going to have these scars for the rest of his life, and they will remind him of this event. And that's an emotional scar, which no one can imagine having to live with. Now, I would note that there's another victim in this case, and that is the mother of Julian. I'm not here to sympathize or to make commentary on the decision of another court to terminate her rights, but that's what has happened as a direct result of this. And, I've gotten to know Miss Tucson. She loves that little boy. Now, we can argue and we can debate whether or not she made good parenting decisions on that night, and she didn't, but she can't have any contact with this little boy anymore. And that's as a direct result of what this defendant did. So this defendant's actions are far-ranging. They're just an emotional bomb is what he's set off in this case. And I believe that considering the fact that we don't know why he did this, which means he's just as likely to do it again, the most important factor I would ask this court to consider is that up until this point, right now, here today, there has been zero remorse shown for these activities. And I'm not suggesting that he has to admit guilt, because he doesn't. He has a right under our Constitution to not admit guilt. He has the right to continue to proclaim his innocence. But I would ask the court to think back to that 911 call, or to that interview with the defendant, with Detective Reisman. He never shows any concern for this child, and up until this point, he still hasn't shown any remorse for the activities or the injuries to this child. So in the people's position is that this court should sentence the defendant at the top of the guidelines, which is 37 and a half years, to the maximum of 70 years in the Michigan Department of Corrections. And I think that would have serve two purposes. One, it would put the defendant at an advanced age in life, such that I do not believe he could be in a position to have more children, and certainly he would be in a position at that point of being a convicted felon of torture and child abuse, that certainly it would give someone pause to engage in a relationship with them and have children because of the fear that he could do this to other children. And separately, I think it just sends a message to our community at large that this type of behavior on 3-year-olds is not going to be tolerated. Thank you.
Mr. Wince, is there anything you'd like to tell me before I impose sentence?
I just want to say, throughout this year, Your Honor, spiritually, I became a better man. At first, when I came here, I didn't know what to do. I didn't know if I should give up or if I should keep on struggling through this process. I just want to say, through the likeness and guidance of God, I was able just to stand strong and still say that I'm a man. I took care of my niece and my nephew since they was kids. I never heard them. The prosecutor saying that I heard kids. I never heard a kid. He's saying that this is an example to set on an innocent man, even though I got found guilty by a jury. But that don't mean I did it. They could have found me guilty of them pictures. They could have found me guilty of just, I don't know, but it wouldn't, my testimony is real. I mean, I said some things that wasn't accurate in the interrogation room, but I ain't mean a lie. I meant to tell the truth. When he came and asked me, did I want to ask questions, my flesh told me don't go do it, because I know what he wanted. He just seen me from where I'm from. He just wanted me to come before he could lock me up. But my heart told me to go because I ain't got nothing to hide. You know, I'm just asking you to give me leniency and mercy, because I'm not a bad man. I'm a good person. I mean, I understand I have a criminal record of home invasion, but that was just one time. After I did that, after my mom set me straight, I got 2 jobs. I had a son. I went to school. I wasn't doing nothing bad. I never did anything to hurt nobody. I take responsibility of leaving him. They'll hunt me every day. But the fact to say that I tortured a kid, why would I do that? I had no reason to. But the thing I'm just asking you, Your Honor, is just for my family, for they won't leave her, even though 22 years is a lot. Well, under, I don't know how this is. 30 years is too much for somebody that ain't a bad person. When I've been in jail a whole year, you can't ask for an officer, have I had a problem with him? I haven't, even though I came here on something that wasn't true through a detective. But I'm not a disrespectful man. I respect my elders. I respect people. And I just pray and ask God that He lead you the leniency and the grace to give me something that I can stand. And I love my family. And I want to let my family know. Stay strong, because I'm going to stay strong. I'm hurt. But I don't know how long it's going to last. I love y'all. And to Julian, I'm sorry that I left you alone. If he's not here spiritually, I know he can feel me. If you walk through this door right now and to tell you that I didn't do this to him, that I only left him alone, then what would happen? Will I still get sentenced? Torture and child abuse first degree after they come out of the kid's mouth for some couple of years later on when he tell the truth? Then what can Mr. Hallam say? Can he say this because I got found guilty by 12 people that don't even know me? Don't know nothing about me. They only knew what the tape said. They don't know me. They don't know the boy that cries inside the man. I want to say, just have mercy and grace on me. And leniency, O'Brien.
Well, the jury didn't believe your defense, and the child's injuries were devastating. It is the sentence of this court on count 1, torture, that you serve 380 months to 65 years in the Michigan Department of Corrections with credit for 393 days. You must pay $68 state cost, crime victim assessment of $130, and court costs of $1,611. On count 2, child abuse, first degree. You must serve 120 months.
Touch me, Rick. Where you were?
120 months to 15 years incarceration with Michigan Department of Corrections credit for 393 days concurrent with count 1. And on
What though, prosecutor? What you want to prosecute me for, man? I'm a good man. I ain't never do nothing, man. I ain't do shit to that child, man. What y'all prosecuting me for, man? What y'all prosecuting me for? What I do? I ain't do nothing. No, this ain't right. This is not right, man. This ain't right. Y'all made me for myself.
I'm the pastor. Calm down. Calm down. Now, this ain't gonna help. I'm your pastor. Calm down. I'm your pastor. Calm down. I'm your pastor. Calm down. Calm down, Sister Harris. Okay, this isn't gonna help. This isn't gonna help now. Okay. Okay. Y'all calm down. Have a seat. Have a seat. It's not going to help. Sit down and hear
But I mean, he's not here to admit.
He's still having time. Okay?
I have no objection to those who want to leave, leaving, because I will need to have the courtroom quiet for me to continue.
Right.
Can we approach, Your Honor?
Certainly. I need to conclude the sentencing. And I can't have outbursts in the courtroom, either by the defendant or the family. So I want everyone to leave who thinks that they may make any noise during the remainder of the sentencing. If you're going to cry, you need to leave now. Can Mr. Wince be brought in for the remainder of the sentencing? So apparently, we're going to need to conclude this on another day. He is in another courtroom now. So we're going to adjourn the sentencing. I can do it tomorrow. Well, maybe next Monday.
Your Honor, may we approach again?
Or-
I guess it's better than complete.
No, I think we're doing Wince.
10 Cheryl.
Because maybe I'm not.
I don't think I'm getting a lead. Yeah.
So here, I wouldn't. You think so? Yeah, I wouldn't. Oh, no. No reason for you to be there.
I'd rather. So this is the. Okay.
Blake Allen on behalf of the people.
Yes, it is. Thank you very much. I do cherish that. Let's go sit in the jury box.
Not me.
That's what they were recommending.
Oh, do you want to go talk to your girl?
Good afternoon again, Your Honor. James Fifelski on behalf of Harvey Wince.
Good afternoon.
Do you have a time?
She's either going to have a hearing or she's And I'm sorry, Your Honor, Robin Stevens appearing with on behalf of Mr. Wince on the 09-2166.
Take off.
I'm ready. You got the right.
Good evening, Mr. Wince. As I was saying, I was imposing sentence on count 2, child abuse, first degree. It is the sentence of this court that you serve 120 months to 15 years with Michigan Department of Corrections credit for 393 days, concurrent with count 1. As to count 3, assaulting, resisting, obstructing a police officer, 316 days incarceration in the Washtenaw County Jail with credit for 316 days served. You must pay $68 state costs and crime victim assessment in the amount of $130. There is a form that Mr. Fifelski is going to be handing you. You're entitled to file an application, you're entitled to file to appeal to the Court of Appeals your conviction and sentence. If you're financially not able to retain a lawyer, you may request appointment of a lawyer to represent you on appeal. The request for an attorney must be made within 42 days of sentencing.
Your Honor, and I am handing that form to Mr. Wince. Do you acknowledge receipt of that form, the appeal form?
Yes.
Okay, here you go. Thank you, Your
I
Honor.
believe that concludes the sentencing. Count 2 did not have any costs.
And then I think
Okay. So there are really two different victims, as the police officer and the child. So I think technically we could charge the crime victim assessment on each of
Yes,
those. So I'm going to keep that as is. Okay? Anything further on that file?
Nothing on this, Your Honor. Thank you.
No, Your Honor.
So then we need to turn to the other case.
Your Honor, I've had an opportunity to meet with Mr. Wince about the probation violation. It is my understanding that he is going to be admitting to the violation. And I talked very briefly with probation. What we would ask the court to do is impose immediate sentence, particularly in light of the sentence that's just been handed down. but to consider 1 year in the Washtenaw County Jail with credit for the time that he's already served and to close up this case.
I would leave it in the court's discretion, Your Honor.
Okay. Please raise your right hand to be sworn.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
In case number 092166FH, you're before the court on a bench warrant to show cause why you shouldn't be, well, the allegations are violation of probation. Condition 1, that you were charged and found guilty in the case that I just sentenced you in, and you also pled guilty under Holmes Youthful Trainee Act in 14-2, docket number 11864, to OM to interfere with police with an offense date of 6/18/11 per an Eastern University of Michigan report, and placed on a deferred sentence. Does he have a copy of those violations?
He does, Your Honor. But no, that's okay.
You have a right to a contested hearing on those probation violations. The maximum penalty on the home invasion is 15 years and/or $3,000, and on the stolen property offense, maximum of 5 years. So to those allegations, how do you wish to plead?
Guilty.
Fine.
Guilty.
If I can have just a moment, Your Honor, I'm sorry.
No, I wouldn't have a problem with that.
Thank you. Okay. Your Honor, it's my understanding that as to count 1, there is some concern about him entering a guilty plea in that he may be appealing that case. And so anything that's said in this case could be used against him in that case. It is my understanding that the prosecutor would not object to the court taking judicial notice from the jury finding on that case to find that he has violated his probation as it is stated, as opposed to him entering a guilty plea.
And a no contest plea as to count 1?
Correct.
That's correct. I have no objection to that, Your Honor.
I heard the testimony in that case. I do take judicial notice of the testimony in that case and the conviction, so I will use that to establish the factual basis for count 1.
Thank you, Your
And
Honor.
as to count 2.
As to count 2, I think he would be admitting to that. Is that correct?
Yes, ma'am.
Okay, and what did you do that makes you guilty of count 2?
Pled guilty under Harvey, 14th District Court, interfering with police.
Do you believe there's a sufficient factual basis?
Yes, Your Honor.
Yes, Your Honor.
I do accept both pleas. I find them to be knowingly, accurately, and understandably made. So you want immediate sentencing?
We would waive any production of a report, Your Honor, and again would request the court sentence him to 1 year in the Washtenaw County Jail, credit for the time that he's already served.
And I assume it is pro forma, but that the court would be revoking his hideout on those files.
Absolutely. Revoke probation, revoke HIDA, and is there anything that you would like to say before I impose sentence? Anything further?
Nothing further, Your Honor.
It is the sentence of this court on the probation violations that you served 365 days in the Washtenaw County Jail with credit for 393 days time served.
Thank you.
There's a form that you're being handed. You're entitled to file an application for leave to appeal that conviction and sentence. If you're financially not able to afford an attorney, one can be appointed to represent you. The request for a lawyer has to be made within 42 days after sentencing. Good luck.
Thank you, Your Honor. You're welcome. Good luck to you, Mr. Wince.